Good. Hi. Good afternoon, everyone. Welcome. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. We do these calls every Thursday, once on LinkedIn Audio and once on our private bridge where you are. The format is going to be as follows. There are some questions that have been posted on our forums.immigration.com. Those questions will be prioritized. Within those questions, higher priority will be given to questions that I've marked as frequently asked questions. They are, I think, the most important ones. I'll address those first, and then they'll be posted on our website as well as on YouTube pages. The question each time will be followed by a period where you can ask related questions. No new questions at that time, but related questions. Normally, I lock the conference when I feel I have enough people here, and any more, I won't be able to answer their questions. Already we have enough people, so I might want to just lock the conference in a few minutes. That way I can guarantee that people who are here, I can attend their questions. Also note that these calls are being recorded and they will be made publicly available, as you heard when you logged into the call. Feel free to conceal your identity. You don't have to tell me who you are. Okay? So with that, let me lock the conference. I just think that we have enough people. Hold on one second.
The conference is now locked.
Okay, so let me begin with the first frequently asked question. I'm recording my screen as well as we talk. So where are the, this is not the, sorry. I think I'm in the wrong screen. Let me go back to today's calls, January 18th, 2024 questions. All right, here we go. The first frequently asked question was, and somebody just asked me about the 60-day grace period after H-1B layoff, how it works. So this is a similar question, but it's so frequently asked, I think I would want to record it again. Okay. H-1B layoff, 60 days grace, options including B1, B2, approved I-140 severance pay. These are the issues that were raised. Okay. So the question here was, I was recently impacted by a layoff. My last day on payroll is 10th February 2024, and I will also receive a lump sum within 75 days of February 10th, which is the day of the layoff. Now, one thing you want to remember that before I go forward with these frequently asked questions, I want to lay down a couple of things for your consideration. First of all, this 60-day grace period is not really 60 days. It is 60 days or the time that remains on your I-94, whichever is less. So if you have 45 days remaining on your I-94, you won't get 60 days. You'll get 45 days grace period, number one. Number two, the grace period begins after the last pay period ends, not the day you stop working. So let's say I stop working in January, but I'm getting my full salary for February and March. My 60 days will begin after March, after my pay period is over. And this is true even if I get, let's say, paycheck on March 1st, and it covers me all the way to March 31st. Okay. Now, so I got the paycheck 1st of March, covers me to March 31st. My 60-day grace period will begin on April 1st. Okay. Keep this in mind as well. And all this is pretty clear. But here is the last point, which is the point about my severance. Is that considered to be regular salary? And that's a very difficult decision. Government has never spoken to it clearly, but there are some cases in which severance was not considered by the USCIS to be regular salary. Now, what is the distinction between regular salary and your severance? One, the amount may be completely different. Two, it may not follow the regular pay period timings. So these are the issues that you need to be aware of. Nobody has a clear answer for these questions. Okay. So those are the three elements that you begin with. Now we begin with the answers. What are the options, if any, to extend my stay beyond the grace period. So obviously, if your spouse is on F1, H1, L1, you could go to a derivative visa. You could go to curricular practical training back to school if you wanted. You could go to, which is the most usual option, B1, B2, which is applying for a tourist/business visa. How to do that is on my blog. You can go to immigration.com. The top ribbon has referenced or linked to my blog, Rajiv's blog. You can go to my blog. About fifth entry from the top is about how to apply for a B1, B2 visa online, or B1, B2 status online. Okay. Second question, many suggest applying for B1, B2. I'm single. I have no spouse to move to H4, etc. Okay. But I also hear if it is rejected, then the time of my stay will be an illegal presence. That is absolutely false. That is absolutely false. Whenever you file a change of status application to B1, B2 within the 60-day grace period, if let's say 5 months later you get denied, that 5 months is legal status. That's called authorized period of stay. Okay? So you are not going to become illegal retroactively. That's just silly. But the situation is different if you apply on the 61st day. Now you are running unlawful presence unless the tourist visa is granted. So if you do it within 60-day grace period, no issue. Don't do it after 60-day grace period without talking to a lawyer. Last question. Now this is about the lump sum severance pay. And I just explained that nobody really understands the nature of it. So if you are in doubt about the severance pay being regular salary, I would just count 60-day grace period from the date I stopped working. Just be very, very safe. Shiv, that covers all your questions. Let me see, is there something else left? Approved I-140. Yeah, that doesn't look like a question on the I-140. Okay, anybody has a related question related to what I just discussed, please press *5 on your phone. Okay, one person, let's see, two people. All right, 3 people have a follow-up question. Let's begin in the order that you logged in. First login was 917 area code. So 917, please go ahead. Area code 917.
Hello, Rajiv.
Hello, Ji.
Hello.
Yes, sir.
Hello. I had a follow-up question on this. So I'm in a similar scenario. I was laid off November 27 and I am on payroll till 26 February. So as you said, I will be paid the same salary, but just the thing is the new acquiring company, so their pay structure is different. Like my original company, they were doing 24 pay slips a year. This new company is doing 26 pay slips a year every 2 weeks. So the paycheck amount will be less, but it is going to be same money per month or per year. So like the base salary is same. So so that's what.
Yeah, I think you are calling from New York, right?
Yep.
Yeah,
Yeah.
I think in a situation like this, chances are, again, you need to confirm this with your lawyers. Chances are that you should be considered to be receiving your salary, regular salary, just because the pay period changed under the acquiring lawyer should not take away your legal status. I think you'll be okay. But if you are nervous about taking a chance with something like this, you can consider the 60 days that after you stopped working to be your grace period and just apply within that. Okay.
So my company lawyers, they are saying like using the conservative approach,
Yeah.
we should consider 27th November, but this is a more lenient approach when we consider it starts at end of February. So the only downside would be if something gets denied when I'm applying for transfer to the new employer. So they said like at that time, the only downside or like only thing that can go wrong can be I will have to go back to India and stamp it and come back again.
Yeah, that is partly correct. But let's say that you have applied in a period where the government thinks you were already outside the 60-day grace period. If the H-1B is denied after 180 days, you would be subject to a 3-year bar. So that's a very difficult period. Just watch it. Talk with your lawyers. Most lawyers are aware of this issue, and they should be able to guide you through it. I can't comment about all the permutation combinations, but considering when in doubt, grace period to begin from the day after you stopped working is a smart thing to do. Okay.
Okay, but if I apply for B2 now in January, I will be paid till February 26. How can that work? Because
Okay, so
I cannot
remember
be
one
paid on
thing.
B2.
Remember one thing. Getting paid without working is perfectly legal. Okay?
Okay.
Getting paid without working is perfectly legal. There's nothing wrong with that. All right?
Okay.
Good luck, sir.
Thank you.
You're welcome. Area code 945. I don't know which state that is. Let's go to area code 945. You are unmuted. Go ahead, please. 945.
Hello, Rajiv ji.
Hello,
I'm
sir.
calling again. Can you hear me?
I can hear you. Go ahead.
So, so the usual discussion which we always take, like when we are on 60 days grace period, we tend to take change of status visa. Another option you have talked about in one of your videos was that we can always go back to our home country to stop the clock and can come back once we have a H-1B transfer approval.
Absolutely.
5797.
Absolutely.
That is fine or not?
Absolutely. Thanks for bringing that up. When I talk, I don't talk based upon prepared speeches, so I just kind of tell people whatever I remember. But if you wanted to, within the 60-day grace period, go back to, let's say, your home country, which is India. That's perfectly legal. And if you get a job, come back with the new H-1B visa. If you have an existing H-1B visa, you can use that. New H-1B approval and a new H-1B visa or old visa. But you need an approval of another H-1B. Going to India does not in any way hurt you. That's fine.
Okay. My other question related to this thing is that in case, suppose a company who wants you to be hired, like where you want to be hired, basically calls you for a interview, like before giving you a visa. What's the other avenue where we can come back to USA, appear for an interview, and in case we get selected, we can always do again change our status? Is it possible?
Yeah, that's there is no easy answer to that question. You can try getting a B1, B2 visa stamp and come as a tourist. Tell the government you're going for an interview. I doubt they are going to be easy going about giving you a visa, but you can try. I think your best approach, in case you think a personal interview would be needed, is to stay in USA and convert to B1, B2. Okay?
Got it. Yes.
Good
Thank
luck,
you so
sir.
much.
You're welcome. Let's go to California. 669. Go ahead, please. California. Go ahead.
My question is, if I apply for a B1, B2 within the 60 days, my clock would stop the moment I get the receipt notice for that.
No. First of all, there is no clock, but the moment the application is received by the USCIS, you are in legal status, as long as it was received within 60 days.
Okay. And are there any issues that arise after interview and everything if you want to move from B1, B2 back to H1B?
No issue.
Anything that we should be careful about?
No issue. One thing is that normally when you go from H1 to H1 and you do a transfer, you can start working the moment the application is filed. But here you have to wait for the approval. That's the only thing, in addition to what else we talked about. Okay.
And there are two cases, right? Either they will do the change of status from B1 to H1B here itself, or they might ask us to get a stamp.
Yeah, they'll ask you to get it stamped if your B1, B2 is still pending, not decided in your favor yet.
Okay, understood. And one last question: Do you know if consultancy is a better option, or is that something you don't talk about?
No, I talk about anything. In my opinion, any honest employer, because we have a lot of consulting companies who work with us, but They only work with us if they are honest. Usually they don't work with us because I won't cut any corners. I will not do anything shady. So there's plenty of honest companies out there. I'm sure if the job is genuine, they have a project for you, go for it. A job is a job. It doesn't matter whether it is in-house or a staffing company. Well, staffing company is a bad phrase. I would say consulting companies. Many of them have projects as well. Right?
Correct. Thank you, sir.
You're welcome.
That answers.
Good luck. Good luck. See, I always have a problem with companies that lie for you. Okay? I always tell people, if anybody is lying for you, they'll also lie to you. Okay? It's better to be with people who are honest, who want to obey all the laws, and there are plenty of good companies out there. I wouldn't paint everybody with the same brush. Okay? Let's go on to the next question, which I have marked as frequently asked question. Pardon me a moment. Let me grab some water. So the next question was optimizing H-4 EAD options and bundling premium processing for H-1B and H-4 extensions. So there was a lawsuit last year. To settle that lawsuit, the government said, okay, in future going forward, if you apply for an H-1B premium processing and you bundle with it an H-4 as well as H-4 EAD request, even though you are paying only for premium H-1B, we will premium the whole package. That's what was called bundling. That means you could get a very quick result on your H-4 EAD as well. Okay. Unfortunately, over the next few months after agreeing to this, government has become inconsistent. In some cases, they do bundle the package, they do treat everything as premium, and in others, they just stagger. So you never know when you are going to get an H-4 approval, when you're going to get an H-4 EAD approval. It has all become a big mess. And I know that the original litigants were thinking of filing for a petition for contempt, because if a government agrees to something in court and then they go back on it, that's considered to be contempt of court. However, I don't know what happened to that. That petition was in the making. I don't think it was ever filed. So the question here was, these are my options. Somebody is on H-4, currently on H-4 good till June 24. I can apply for an H-4 EAD first time since my I-94 is valid till June 24. If I do this, can I keep working after June 24 while the extension is pending? No. So if I remember correctly, the rule said you can continue working only if your I-94 is good. So let's say that your for whatever reason, your EAD is expiring today, but your I-94 are expiring tomorrow and your I-94 is good till July or August. Okay. So if you get the EAD extension filed, you are filing within the life of the EAD and your I-94 is valid for several months. I think then you get a grace period of 180 days, if I remember correctly, or the time remaining on your I-94, whichever is lesser. But for most people, I-94 and EAD are expiring the same day. Okay, so that becomes a problem. What some people have done is they have gone and gotten a stamp on their H-4, which goes beyond their EAD. So if you had an old H-4 that was never extended for some reason and your husband or your wife has an H-1 for the next 3 years, you could go to a neighboring country, get an H-4 visa stamp and come back. So even though your EAD is expiring tomorrow, your I-94 is good for the next 3 years. If you file an EAD request today, I think you can do it online, right? So if you do it today, you then have permission to continue working for 180 days, right? So that's what some people did. Talk to your lawyers, make sure that that is the right thing for you, but that is an option. Okay. So apply for H-4 EAD now, since my I-94 is valid till June. Can I keep working after June? So I told you can't work beyond your I-94. Option 2, apply for H-4 EAD again first time, plus H-1B extension, plus H-4 extension using premium. That's the bundling option. So I told you that bundling works sometimes, then it does not work sometimes. Will the H-4 EAD have a validity of 3 years if the H-1B and H-4 extensions are approved for 3 years? I don't remember. I thought they were doing them for 2 years, but no, I could be wrong. My team would know this. I think they are doing it coextensive with the time remaining on your H1, H4. Don't take my word for it. I don't remember it off the top of my head, but that makes sense to me. However, law is like this. Not everything that makes sense is true. Okay. So double check, but I think you should get it for 3 years. Which option is simpler? I don't think any of these options are dependable. There is no way, because first one, we know you can't work beyond June if your I-94 is expiring. So then really the only option that remains that makes sense is to take a chance with the bundling option and attach a copy of the decision on that case. What was it? Ida Kunni or Ira Kunni, something like that. That case where the government made a settlement and the court passed the final order accepting the settlement on the record. So add a copy of that and hope for the best. That's all you can do, ma'am. Okay. *5. If you have a follow-up question on this, please press *5. Okay, no follow-up. Let's go to the next frequently asked question. I think there are 1 or 2 more. Yeah, this is an important one. Implications of visa fraud by an employer on H-1B, L-1B green card citizenship. Okay, so we've dealt with these issues at every level. H-1B, H-4, L-1, L-2, B-1, B-2, F-1, F-2, all kinds of situations. Typically, if the visa fraud was totally the doing of the employer and you were never involved in any way, you should eventually have no issue. You might be called in for questioning. They might say that, oh, well, your employer had a problem, so we think your H-1B should be revoked or your L-1 should be revoked, or we can't give you a green card or naturalization, etc. Okay, but like I told you, we have dealt with this kind of a situation at the green card level, at the citizenship level, and at non-immigrant visa level. Always, 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 as long as you were not in any way involved, ultimately you are able to clear yourself. Okay, so with that said, this is a fairly lengthy email. There was an employer, they had multiple successful extensions. There was, in the middle of year 2020, admin processing was lifted on my petition. RFE was issued. I was already out of the US. No response was given. At this point in time, I came to know that my employer got into visa fraud and money laundering and served jail sentence. Nobody was aware of it. So will USCIS consider my stay between 2017 and 2019 as unauthorized? And do I have a 10-year bar? The answer is no, you do not have a bar. As long as you have an I-94, even if it was issued fraudulently, of course you were not involved, it does not create unlawful presence. There is no 10-year bar. Can I apply for waiver of inadmissibility? You shouldn't have to, because you are not inadmissible. Will my visa fraud case impact H-1B approval in future? And I just answered, you could have delays, but ultimately if you were not a party to the fraud, you should have no problem. Okay. There was a second question from a user who called themselves NS 2020, which were all related. So this is also a case in which employer got into a visa fraud case. And they are also worried that will I be able to claim remaining of my H-1B term? Will my employer's visa fraud issue impact my chances of getting H-1B approved? Note that I've never had any issues with my H-1B approvals in the past. So it appears to me that you have nothing to worry about. Like I said earlier, unless you are involved, you should not have to worry about it. Okay? Star 5. If anyone has a follow-up question on this, press star 5, please. All right, no follow-up question. Oh, there is one. This is from area code 309, which is Illinois. Illinois, go ahead, please. Illinois, 309, go ahead, please.
Yeah, actually, I came here on F2 visa, dependent visa, as my wife is F1.
Can I interrupt you for just 1 second? I'm only taking follow-up questions, no new questions. Whatever I discussed, if there is something relevant to that, we can discuss it now. Otherwise, wait for your turn when I'll call on everyone to ask their questions, okay? I still have to answer the written questions.
Yeah, sure. Okay.
All right, stand by, please.
Yeah.
Okay, so let's see. Then, is there any other frequently asked question? There's one more. This is advantages of a national interest waiver, transitioning to EB1, entrepreneurship, and H-4 employment for spouse. So if you Google my name, Rajiv S. Khanna, the Economic Times, you'll come to my author page. And the most recent article that I have written in January 2024, it talks about why should you be interested in the national interest waiver, even if you are India born, and even if you have decades of waiting. It is advantageous to do an NIW and keep it. Okay, but let's see what these questions are. I entered US to complete my master's on F1, got my H1B. I was planning to do a green card through EB to NIW. Suppose I got my EB to NIW approved and I'm waiting in queue for a green card, but I went back to India and worked in India in a totally unrelated job. Can I collect my green card? Yes. Yes. So that's one of the advantages of an NIW, that even though you are in India, you're waiting for your priority date to become current, as long as you intend to work in the field for which you got NIW, when you arrive in the US, you can get your green card, no problem. Suppose that I've already applied for an EB to NIW, then I build my profile and I want to apply for an EB1. Can I do that? Sure. And you can transfer the priority date from National Interest Waiver to EB1. That's another great advantage. When can I start my business during the EB to NIW process? That's a whole different discussion, okay? Because there is no interim visa that you could use. You could use something like an entrepreneurial parole, but that's very limited use, okay? Very limited use. USCIS right now is considering H-1B regulation change for entrepreneurs. If that works out, then you would have a very good situation, because the NIW will give you the option of extending your H-1B beyond 6 years, and you can work for your own business. When can my wife start working on H-4? She can start working once the NIW is approved and you apply for her H-4 EAD. There's no visa. This is the NIW I-140 petition approval. Okay. Star 5. If anyone has a follow-up question, press star 5. Okay. There is one, area code 267. So this is from Pennsylvania. Yeah, Pennsylvania, go ahead, please.
Hi, Rajiv ji. So what is the NIW? Like, I never heard of it. Like, my I-140 green card is on EB2, but is there a difference between the EB2 versus EB2 NIW?
Yeah, there is. NIW is a subcategorization within EB2 that you get not based upon any particular job, but because of the area that you work in and you intend to continue to work in. So for example, let us say that I am working in cardiac intervention, okay, where when people get a heart attack, I'm doing some research in that area, and I am able to prove to the government that this is going to be in the interest of the United States, which is not very difficult. Read my article, you'll get more information. The advantage is you're not tied to a particular employer. Your I-140 belongs to you. So you can keep changing employers as long as you're working in the interest of the United States in the mentioned area. Make sense?
Yeah, that makes sense. Suppose, say, how do I know, like, see, my priority date is November 2016, and I have my I-140 approved long back. So how do I know, like, can I upgrade my current EB2 to EB2 NIW?
Well, it's not really an upgrade. It's a lateral move. You'll carry your priority date from 2016 to a petition you file in 2024. It just cuts you off from having to depend upon a particular employer.
Okay. So can I do myself this particular process?
Yeah, you can do it yourself if you have the time to read, understand the law, and make a case. Sure.
Or I can get some other attorney.
Oh, absolutely.
Or maybe you to get this further.
Absolutely.
Right?
Absolutely.
So how much does approximately how much does it cost?
Sir, our fees,
I'm still
our
currently with
fees,
my.
our fees are on our website. So if you go to immigration.com,
Okay.
on the top ribbon there is a link to our fees. We list all our fees online. Okay.
Okay. So, yeah, definitely. So, one last question. I don't have the physical I-140 copy, but I have the electronic copy that I got from my employer. So, still I can able to do the.
Oh, absolutely. Yeah.
Do this NIW.
Yeah, you don't need the original. A copy is enough. Okay.
Okay.
Good luck.
Fair enough. Yeah.
All right.
Thank you.
You're welcome. Bye-bye. Okay, for some reason we are very slow today. I don't know why. I'm trying not to be, but let's see. Go to the next posted question. There's a whole lot of them. Medical issues and expired green card. This is question number 3. Medical issues and expired green card impact on authorized stay. Okay. I visited India in 2015, got delayed. Then a medical health issue in 2023. So you've been outside USA for 8 years, your green card is gone. Yeah, your green card expired more than 5 years ago. I doubt it. SB1 is not likely. You can try. But of course, since your family, let's see, my wife and son are both US citizens, your family can apply for your green card again. You should be able to get it like in a year, year and a half, something like that. So just reapply. That green card is gone. I don't see how you can get it back. Okay. So go for that, Palani. If you are here, if you have a follow-up question, anybody has a follow-up question, press *5. All right. Transitioning from STEM OPT to H-4 EAD and planning for the H-1B lottery. Okay. My wife is on H-1B. PERM was filed in April 23. I'm on STEM OPT, lost my job. OPT is valid till June 24. If I'm unable to file for H-1B lottery, or if my H-1B is not picked up, will I be able to get STEM OPT to H-4 EAD in June? Sure. Because once your STEM OPT expires, all right, you got 60-day grace period. You have to apply for H-4 in that 60-day grace period. So let's see, your STEM OPT is valid till June 24. Yeah, so not only June, but 60 more days. So July, August, you could apply and be on H-4, no problem. There's no, I do not find a job and lose my STEM OPT in February. Well, if you lose, before you lose your STEM OPT status, apply for H-4. That's what makes sense to me. Okay. *5, if you have a follow-up question, press star 5. All right. Let me go to question number 6. Name change dilemma, re-entry permit application with pending green card name change. Okay. So you got a green card, you got a name change through a court, I think, right? Local judge approval notice. When we apply for the re-entry permit, should we write the new last name or the old last name? You applied for a replacement green card, you should write the new last name, and you should attach a cover letter with a copy of the pending application I-90 for the name change, replacement of green card. Okay. You can also attach a copy of the order from the court. And that should take care of it. I don't think it should be a big issue. Star 5. If you have a follow-up question, press star 5. Okay. Question number 7. Unlawful presence implications, reinstatement and F1 visa application strategies. My post-completion OPT ended mid-Feb 2020. Then COVID came along. I left. But I left in mid-September. So February to September, a 60-day grace period, right? March, April, so May, June, July, August, September. That's less than 180 days. Okay. You could have applied for reinstatement. I don't think you accrued over 180. Well, you may not have a 60-day grace period. Let me double check. My post-completion OPT ended in February. Post-completion OPT. Yeah, it is post-completion OPT. I left the USA in mid-September. So after February, you had 60-day grace period and you left before 180 days were up. So you were not unlawfully present. I mean, you were unlawfully present, but it was less than 180 days. That has no impact. You can have trouble getting tourist visa or student status, but you will have no trouble with H-1B or L-1 type visa or H-4 L-2 type visa. My question is whether I accrued 150 days of unlawful presence. Well, you also had DS, so you may not accrue. You're right. If you had an I-94 with a DS, there is no unlawful presence at all. But even if you did have it, less than 180 days has no legal impact. Now the problem is you were here illegally. So when you apply for a new F1, they could make that a problem. It is not a problem of unlawful presence. It's a problem of overstaying your visa. So unlawful presence is not causing you the harm. Okay. So I think, and you have to disclose it. Don't try to hide anything. Always disclose. And if you have an explanation, of course, have a letter from the DSO or whatever helps you explain the reason you overstayed. Okay. Star 5, if you have a follow-up question, press star 5. All right. Next question, let's see, which one are we on now? Number 9. Traveling abroad on AP with multiple pending EAD AP applications and H-4 status. Filed for EB3, later EB2, based I-485. So I have 2 employment-based green card applications. So do my wife and daughter. My wife got her EAD AP for one EB3 and one for EB2. Now as renewal is due, I filed for EB3 based EAD AP, which is still in progress. It's too complicated for me to cover here. I think you should talk to the USCIS customer support. I can give you the normal rule, which is no one knows what to do in these cases. Personally, I think if you have one advance parole, it covers both cases, but I would rather have it checked with the USCIS than make a guess for you. Okay. So bottom line is any advance parole should be good enough, but double check with the USCIS. Star 5, if you have a follow-up question, press star 5. Okay. So I can't help you fill forms, sir. Sorry. But if somebody has overstayed, this was my next question. They have accrued unlawful presence as well as out of status. So both of those situations are true, but unlawful presence of less than 180 days has no legal impact. But if you try to get a another student visa, they will not look favorably upon the out of status unlawful period. H-4 EAD processing time and travel restrictions with H-4 change of status approved and H-4 EAD pending. Hold on one second. Okay. My wife had applied for a change of status from H1 to H4 along with her H-4 EAD application in September. H-4 got approved in December. EAD is still pending. Okay, yeah, that's normal. Okay. All right. My question is, did the H-4 EAD processing time clock start from her change of status to H-4? I think it should start from the date the EAD was filed. So I would say it was the date the EAD was filed. Can my wife travel outside USA? Okay, now this is Jay. I don't want to step outside my bounds here because again, I remember reading it somewhere, and I think it was one of the USCIS comments. When you have an H-4 to H-4 change of status pending, in your case it's already approved, you can actually travel abroad without disturbing your EAD, no problem. Okay, but once again, please double check with the USCIS, make sure it's not going to cause a problem. They said they discouraged the practice of traveling with the EAD pending, but they did not think it was going to be damaging or they would consider the EAD to be revoked. Okay, so that's pretty much it, guys. These are all the posted questions. Anybody has a follow-up on the last thing I discussed about the travel? Press *5. Okay, we have covered all the posted questions. Anybody has any question? Press *5, please. Anybody has any question? Press *5. I'll take you in the order that you logged in, okay? So I only have 3 questions from people here. The first one is from New Jersey, which is area code 732. Let me find you. Hold on one second. Where are you? New Jersey, where are you? Here you are. Okay, New Jersey 732. Go ahead, please.
Hi, Rajiv. My name is Chigon, and actually I'm working in California now. So I moved to California, and
Okay.
I'm working in biotech company.
Okay.
And my H-1B approved in last lottery, and my application is also approved at end of June last year.
Okay.
But there was a spelling error in my father's name.
Okay.
And my company is now, my employer is now not willing to change it.
Okay.
Change that one.
Okay.
And in October, our company has a one location only, and we changed to the another city, which is in the same MSA only, like 10 minutes far from the previous location.
Okay.
And they are also not willing to change that on my H-1B approval. So what are the my options now? Can I change that?
Father's name?
Or can I change?
Hold on. Is the father's name a part of your name?
Yeah, it's like how you. It's my.
Yeah, no, I got it. I got it. So how much is the error? I mean, is it a lot of difference in the name? Is it just the spelling error?
No, just one H is missing. Yeah, just spelling error. Just one H is missing.
You see, remember one thing. We Indians, when we convert our names to English, we are not spelling. We are actually imitating the sound. So, for example, Rajiv can be R-A-J-I-V, R-A-J-I-V-E, R-A-J-E-E-V. They are all correct. Okay. But whenever I have a problem with the name, the first thing I ask is, did you guys make a mistake or did USCIS make a mistake?
It is a mistake made by the USCIS.
That can be corrected very easily without any cost. You can let your employer know.
Still, my employer.
Okay.
Yeah, I know that. I told them, but they are not willing to even correct that one because it is not filed by the attorney. It is filed by some normal guy in the company. and he don't know how to do that.
Oh,
And he
you can
don't
show
want
it to
do
them.
that
If
also.
you do a web search for USCIS typographical correction, you'll come to an online site where it can be done in 2 minutes.
Yes, but that's the thing. Like, it is more than 6 months now. They don't willing
Well,
to
they
do
can
that
still
also.
do it.
And I cannot
They
even.
can still do it. But the problem is, whenever there's a name discrepancy, even though we are doing phonetic spellings, I worry that are they going to put you in secondary inspection, ask you all sorts of questions. Ultimately, I think it's going to be okay, but why leave something like that hanging out? Now, that's one part.
Yes. Yes.
Second part is, I am quite alarmed at how poorly the companies do when they think they know the law. Okay, so even if the change in location is within the same MSA, they still have to do job posting notices on the new premises. If they don't do that, they are in violation of the law. Okay, so is this going to cause a big problem for you? I don't think so, but it is a violation by the employer. They should correct that. Okay. So bottom line, you can't do much. Look for another job, go to another employer, get everything corrected.
Yeah.
Okay.
Yeah. So if I will transfer my H1B, so then it will be, I can transfer my H1B, right? I can find.
Yeah, you should be able to transfer. I don't think you're going to have
transfer my H1B.
You're not going to have any problem in the transfer. I think you'll be fine. Okay.
Okay. Yeah. Sounds good.
Good luck,
Thank
sir.
You, thank you, Rajiv.
Good luck.
Yeah. Thank you.
You're welcome. I have 3 more questions. Another one from California, 949. Let's go to 949. Please go ahead, 949.
Hello.
Yes, ma'am.
Hello.
Yeah, I can hear you. Please go ahead.
Hi, Rajiv. I can hear. Can you hear me?
Gigi, I can. Go ahead.
Yes. So my question was, I'm working right now in a company in California, and my manager is here on a contract basis. He has his own company. So he also offered me a job offer. So he's willing to file for my H1, and my current company where I'm working, they're also willing to file for my H1. So I just wanted to know, with the new laws coming in, can both of them file my H1, and either of them?
Well, hold on.
Can I?
Hold on.
My manager.
Hold on. We don't know when the new laws are coming. Okay. So if we were to go with the old laws, I think filing from these 2 connected companies is a bad idea, because you have the same officer in the 2 companies. So I would not file through 2 companies. Old law. New law is even more strict. Okay.
Okay, but the thing is, he's a contractor, so technically he's not the employee.
I still wouldn't do it. I think the range of how they cover these related companies, that is a very wide net. I would not want to take a chance with that, ma'am. I would just pick one company and go with that. Okay.
Okay. Thank you.
You're welcome. Good luck. Next one is also from California, area code 669. And then we have one more. That's it. Area code 669. Go ahead, please.
Hi, Rajiv, sir.
Hello, sir.
I had 2 very quick questions. If after I shift from H1B to B1, B2, is it how long can I be in the US after that? Is it same as like the 6 months on tourist visa?
So
Like
when
maximum?
you apply, you'll ask for 6 months. Okay. And you can stay in the US as long as the application is pending or until the 6 months are close to getting up. If the 6 months are close to getting up, you can apply another extension while the first one is still pending.
Okay, so you have to apply for a specific time period for B1, B2?
You have
It's
to
not
ask
like
for
regular.
Yeah, typically you ask for 6 months. That's all they give you.
Okay, understood. And second question was, we spoke earlier and you mentioned that unpaid admin leave does not help.
It does
a company provides that.
It does not.
What other options can help in this scenario?
Getting paid your
From
full
the
salary.
company? Okay, so anything which has me as their employee, even if they give me a 2-week notice period and pay me my full salary, that extends my two.
That
gives
will,
me 2 more
yes,
weeks,
that
right?
would
Because they're paying my.
that would extend your grace period for 2 more weeks, because the grace period will begin when the pay period will end.
Okay, anything that shows regular payment, the same amount, and yeah, okay, understood. And B1, B2, and consultancy are the only options, right? To look for a like if you don't have a job and the 60-day period is on, those are the only 2 options.
Well, no, I discussed
that
other
can be
options.
considered for a
I
single
discussed other options today. If you are not here, you can rewind and listen to the recording. Well, things like derivative visa based upon your spouse, going back to school, things like that. But yeah, those are very limited options actually.
Correct. Derivative visa is based on spouse. Okay.
Yeah.
Understood. Okay, right. Perfect. Thank you so much, Rajiv.
You're welcome, sir.
I appreciate your help.
You're welcome. Good luck. Area code 267, Pennsylvania. Go ahead, last question of the day. Pennsylvania, go ahead, please. Area code 267, I can hear you.
Hi, Rajiv. Hi, Rajiv.
Hello, sir.
Right now, I have my, with my current employer, I have my approved I-797. So my question is, I'm traveling to India on Feb 10th. So I found a new employer who is ready to transfer my H1 visa. They offered me, I signed the offer, and they started the process of transferring my visa to their company. So here my question is that, suppose say, if I get the, they said like they are going to apply on a premium process. So if
the conference is now unlocked.
Sorry, go ahead. They're going to apply for premium process?
Yeah. Before Feb 10th, if I don't have the physical copy of approved I-797 with the new employer, can I still travel to India?
Traveling is not, you're doing an H-1B transfer, right?
Right. From my current employer to new employer, they just started the process.
Right. Right.
I mean, like they said, like they are going to do on a premium process.
Yeah.
But my question here is that can I travel to India? Still, my new H1 transfer is in process.
Yeah, you can travel. That's not a problem at all. But the question is, can you come back? So to come back, you need a valid visa. You have a valid visa on your passport right now?
Yeah, I have my valid visa with my previous company, which is good until July 2024.
Okay, so you can.
But
okay, hold on, sir. Let me finish. It is settled law. There is no argument about it. If there is an H-1B extension pending, you can travel without harming your transfer or extension. You can travel without harming them. There's no problem. Okay. To return, you must have a valid visa, and you should be able to return even though currently your case is still pending. It's not approved. This is a big exception to the normal rule. Okay. So hold on. Let me just lock the conference again. I was waiting for one person. 1 second.
The conference is now locked.
Does that make sense? So normally you can't travel when there is a change of status pending. So if you have applied for F1 to H1, traveling means you have to wait outside, get an H1 visa stamp and come back. But when there's an extension or a transfer of H1, you can travel and return with an old visa, no problem. Okay?
Okay. So, my question is that, like, as I told you, suppose with my previous employer, in this case, let's say like employer A, with that employer A, I have the visa stamped, which is good until July 2024. And with my current employer, which is employer B, I have my approved I-797. And my new employer, which is like employer C, they started the H1 transfer process, and as you know, they have to first raise the LCA and then they have to do the transfer.
Oh,
So in that
hold on,
case,
hold on, hold
what
on, hold
attorney
on,
was
hold
saying is
on.
that
Sir, let me get a word in. I'm going to give you half a minute more, then I have to go on, okay? So you talk to your lawyers, you have lawyers. I am telling you, you can travel. That's what you need to know. The details you can discuss with your lawyer. But do not travel before your transfer is filed. Your transfer must have been filed before you travel, and you must return before July. Okay? Talk to your lawyers, get the details from them.
okay.
Good luck.
So,
Sir, you're going to have to end this somewhere.
So, can I travel with the
Go ahead. Go ahead.
Sorry.
Go ahead. I said you're going to have to end somewhere.
So, suppose they applied it.
Go ahead.
They applied and I have the receipt nursery.
Mm-hmm. Yeah, you can travel.
So, with the help of the... Okay. Thank you.
Yep.
Thanks, Rajiv.
You're welcome. Good luck. Yeah, because see, you have your own lawyers. Go talk to them. I've given you the way. At least discuss the details with them. They get paid for it. I have other people who are waiting. So please be respectful of my time too. Okay. So let's go to, there's one more person. I'd let them enter because they had a question. Pennsylvania, area code 412. Go ahead, please. Area code 412?
Yes. Hello, Rajiv, sir. Thank you for letting me in.
Mm-hmm.
Can you hear me?
I can. Go ahead, please.
Okay. Yeah, sure. So my question, as I posted earlier, was that I'm currently on day one CPT and I'm married, engaged to a U.S. citizen.
Mm-hmm.
But my situation is a little complicated because I'm on day one CPT, so I cannot travel.
Mm-hmm.
And because I cannot travel, I can't go and get married in India. And because of that, I'm not able to start my green card process through marriage.
Mm-hmm.
So I wanted to know what are the options I have. Question number one, if I do apply my green card from India, I heard that the waiting time is around 18 months, which is too long.
Mm-hmm.
But do you recommend that, or would you recommend staying in USA and applying, like going for court marriage and applying it from here, which our families don't allow as of now? And if not this, do we have any other option? And the another question I had was, let's say if I get my H-1B, my company is filing for my H-1B in March. And if I get my H-1B in March, can I travel on H-1 and start my green card process through marriage? Like, if
Absolutely.
I have started, can I still travel on H-1?
Yeah,
so these
absolutely.
Are the questions that I had.
Absolutely. When you have an H-1B, you can go to India, get married, return on H-1B visa, and apply for your green card. No problem.
Right.
Okay.
Right.
But when
and
you
let's
are,
say if I don't get my H-1,
if you don't get an H-1B, you have to make a decision. Either you go to India and stay there, wait whatever time it takes to get your green card or K3, okay, or get married here, start the green card process, wait 10, 12, 14 months for an advance parole, get the advance parole, do the religious party and everything in India after you go there. Those are the only two options.
Right. So do you recommend applying from India? Is the waiting time too long?
I can't predict. I have no way to mathematically pin down the time. So 1 to 2 years is normal.
Okay. So will it help me anyway if I apply from USA versus I apply from India?
Of course. If you apply from here, you get your EAD eventually. You get your advance parole, which makes it able to travel without any questions asked. So applying from here has the advantage of being able to be together and stay in USA. Applying from India has the advantage of being able to eat pani puri and stay in India for 18, 20, 24 months. So pani puri or husband, choose.
Right. Yeah, I think I would rather stay here because I also have my job here. So
Okay.
Pani Puri takes a backseat right now.
Okay.
But yeah, so and that means I cannot travel on D1 CPT, right?
No, that's a bad
It's a
idea.
risk.
I
At
think
least
you never know
that's
what they're going
knowledge.
to do. Why take a chance?
Agreed.
Okay.
Yes, got it. Yeah, so that means I don't have a lot of options. These are only my two options,
Yeah.
which are still good options. But then the last question that I had, let's say if we go for court marriage, and obviously we haven't done any traditional marriage, and it's going to be an interreligious, interfaith marriage. Will it raise any questions as to you are doing court marriage without your parents here? Will it raise
Absolutely.
any questions in the interview process?
Yeah, it will raise questions, but the questions become easily answerable because you are doing it to make it so that you don't have to be away from each other for 18 months, which is the truth. And then you also have a great big party in India, and that take pictures and bring back pictures. That should take care of it. No problem.
Okay.
Perfectly legal.
Understood. Yeah.
Yep.
Thank you, Rajiv.
You're welcome. Good luck, guys.
Okay.
Yeah.
Thank you.
You are very, very welcome.
Thank you.
Take care, everyone. Good talking to you. See you next week on LinkedIn. Bye-bye.